The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, I'm Kevin O'Flaherty from O'Flaherty Law. I hope you find this Learn About Law video and podcast helpful. If you need some help, please feel free to give me a call at 630-324-6666. That's 630-324-6666. Thank you so much for watching and listening.
Hi, this is Andrew with Learn About Law, and in today's video we discuss how often you can file for bankruptcy in Illinois. So the bankruptcy system allows for multiple filings within a given period of time, but there are strict guidelines, right? So filing too close together or deliberately trying to game the system can result in your case being dismissed without a chance to file again, fines, or on rare occasions, jail time if fraud is involved. So how long must you wait between filing the same chapter bankruptcy? So between Chapter 7 and Chapter 7, you need 8 years since the last discharge rate. In between Chapter 13 and Chapter 13, you need a minimum of 2 years since the last Chapter 13 discharge date in order to file for another Chapter 13 bankruptcy. What about filing between different bankruptcies? So from Chapter 13 to 7, you must wait at least 6 years from the filing date, unless in the previous Chapter 13 bankruptcy you paid back all your unsecured debts or a minimum of 70% of your unsecured debts through the repayment plan. With Chapter 7 to 13, normally you must wait 4 years. However, through Chapter 20 bankruptcy, you can gain some of the benefits of both types of bankruptcy, but also there are some drawbacks. Chapter 20 bankruptcy is not always an option, so it's best to discuss this with your attorney. As long as you're not willfully committing bankruptcy fraud or filing for bankruptcy in bad faith, you shouldn't have to worry about any criminal or legal troubles. However, with each attempt to file bankruptcy or refiling, especially if you're trying to cut the regulated time period short, you may be penalized. The most important penalty to be aware of, outside of doing something that is illegal, is a nullified automatic stay. If the court dismisses your bankruptcy case for whatever reason, and you attempt to file another bankruptcy case in less than 1 year, the automatic stay will only last 30 days. In subsequent filings, you may not be eligible for the automatic stay at all. In this case, your only option is to file a motion with the court asking for the automatic stay to be extended. If the court finds that you've been deliberately skirting the system, this would be such as multiple filings in order to delay creditors, the bankruptcy court will likely block you from filing another bankruptcy for a specified period of time, cut your automatic stay short, or seek legal action in more serious cases. If the court dismisses your case in this way, it is referred to as a dismissal with prejudice. You don't have a lot of options if you've been locked out of the bankruptcy system. If your case was dismissed with prejudice, you can refile for bankruptcy or appeal your original bankruptcy dismissal. If your Chapter 7 bankruptcy was dismissed on the grounds that you don't qualify, you can still file for Chapter 13 bankruptcy. The most important first step when considering bankruptcy is seeking the guidance of an experienced bankruptcy attorney. So give us a call if you have any questions about bankruptcy in Illinois. And as always, thank you for tuning in.
Hi, this is Kevin O'Flaherty again from O'Flaherty Law. Just want to let you know we offer free consultations in many areas of law, and we have several geographic locations for your convenience. So if you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. And thank you again for watching and listening.